Of course, I knew Balagopal. I met him in a number of meetings. I, of course, read of his writings quite comprehensively, whether they were in EPW, whether they were in any other place, whether they were in a book form, article form, etc., etc. And he was always, he'll remain a legend of the human rights movement in India. So there is no question about it. But being at a distance, being in the, Maharashtra, Bombay, Hyderabad, there obviously being a distance, while one always admired him, one wondered how he did the kind of work he did, I didn't realize the kind of love which he evokes till I came here, until I saw today's meeting. 13 years after the death, 13 years, right? 13 years after death of Balagopal, so many people from morning coming here. We are just instances. I'm sure all of you are here because of that Balagopal. So that itself, I feel that if even in my funeral, if 1/10 of these people are there, I feel it's a life well lived. So, and as he used to say, and that is something which I had forgotten today again a few days back. I was just listening to his interview on your website, where he used to say that, look, our theory should develop from our praxis. That's one thing which he was very clear about. It. You don't theorize first and then go and practice something. You practice and then from there evolves the theory. And that's, I think, very true. And we should never forget what he said in that context. Now, I'm going to repeatedly commit contempt of court during the time when I speak. So, Arundhati is of course used to it, but that's fine. So, bear with me. There is as yet no vicarious liability for contempt, so you can relax and listen. What I'm basically going to do, because what the topic which I have been allotted is Hindutva and how is the judiciary impacted? What is the impact on the judiciary because of Hindutva? What is the relationship between the two? And I basically follow a simple model. That is, there are 4 or 5 things majorly which Hindutva does or seeks to do. And how has the judiciary responded to those 4 or 5 things in the last 8 or 10 years? That's what I'll take each issue and go into how the judiciary has responded. And when I talk about judiciary, I'll by and large talk about the higher judiciary or the constitutional courts, by and large. But before I go into that, I think one thing which a lot of people have in their mind, not just here but everywhere, is this government going to change our entire constitution? Are they going to dramatically either alter or change or scrap and bring about a new constitution? This is one question which comes to people's mind. The answer curiously lies with the judiciary. And even more curiously, the answer would depend on whether the judiciary is going to allow the present establishment to get away with the things which they are doing. Then they don't want to change the constitution. They don't want to get into that exercise. It's only if the judiciary stops them from doing certain things will they say that, okay, let's scrap this constitution, not good enough. So remember, in the last 10 years, last 8 years of the BJP rule, there have been only 4 major constitutional amendments. Yeah. When we talk about they wanted to scrap the constitution, etc., there have been only 4 major constitutional amendments. First one was the NJSC, that is National Judicial, whatever it was, that they wanted to change the way in which you select judges. The selection of Supreme Court and High Court judges was going to be changed by bringing about an amendment to the Constitution. That, of course, Supreme Court for its own preservation struck down. Okay. So that went out. Second amendment was pertaining to GST, which was brought in through a constitutional amendment. That is something which nothing is happening in courts, etc., etc. I mean, people will argue about whether it should be 10%, 12%, 16%, etc., etc., retrospective, not, etc. But whether GST itself should be there is not something which has been challenged at all. And remember, that is one part of the center's, the Hindutva's focus on centralizing all power. That power should not be with state governments, it should be with us. And this is one reflection of that. There are many other ways in which the third constitutional amendment, of course, which they brought was Article 370. So that is going on in Supreme Court right now. Whether 370, but looking at the history of the Supreme Court about Kashmir issues, I don't think we need to have much hope from this great institution. So, I mean, forget about that. That's not going to, I mean, if we think that they are going to strike down 370, I am very skeptical about it. And it doesn't matter whether Lalit is the Chief Justice or Chandrasekhar is the Chief Justice. Please, I mean, that's not going to make much of a difference to the core issues of the present establishment. It may make a difference to some other issues, okay? But to the core issues of the establishment, it's not going to make a difference. Fourth amendment which they brought about is the economically backward section reservation, okay, which was for the first time introduced, which is not available to the Dalits, okay, or the scheduled tribes. Okay, that's for the upper echelons. That is the fourth amendment. That is again going on in court. The judgment is reserved. We don't know what is going to happen. They might uphold it, they might strike it down. But these are the four amendments which they have brought in. But apart from these, they are not really tempered with the Constitution. And the reason is very simple. That if you have the word secularism in your preamble, even if you have Article 25 in your Constitution which guarantees fundamental rights, even with all that, if you can massacre the Muslims, how the hell does it matter what the Constitution says? Constitution can go on saying anything it wants. Okay? I mean, look at the CA-NRC. You have 7 articles of the Constitution, right from the Article 5 to Article 12, dealing with how citizenship has to be given. You do away with those principles and you introduce your CA. Okay? Now, if the Supreme Court upholds it, how does it matter whether the Constitution is changed or not? It doesn't matter at that. Okay? So please, I mean, this dramatic only thing, if they will think about changing the Constitution, if CA is struck down, if Article 370 amendment is struck down, then yes, then they will say that okay, now enough is enough. Now we tolerated the Supreme Court for sufficient time, now let's get rid of it. Let's get rid of this Constitution. That's a different matter. But otherwise, this change in the Constitution is not very likely to happen as long as the Supreme Court toes the line. Supreme Court toes the line, there is no need for changing the Constitution. That's the reality of the situation. Now let me come back to what I was talking about, Hindutva, etc., etc. There are a few things which we obviously know about Hindutva, which are well known. That it's anti-minority, that it is patriarchal in its structure, that it is anti-Dalit. These are the things we know. And I think all of us know that, and how the Supreme Court deals with it, I'll come to that. But there are a couple of other things which I would like to highlight. We know about the Ayodhya judgment, we know about Gyan Vapi, etc., etc., how the Supreme Court has been dealing. There are a couple of other things which I would like to highlight. Hindutva is a homogenizing project in the sense that they want a complete plurality has to be done away with. Okay. In order to do that, three of the things are needed to be done. You need to centralize power at the center. So you have to attack the federal structure of the way things are. So you attack the federal structure. Second thing is, if you want to homogenize, and if you want to centralize, and if you want to then implement your Hindutva project, what you need to do is to crush any kind of dissent. You do not want, it's a homogenizing project, and any homogenizing project will not brook of any defense. Okay? So you will want to crush all kinds of defense. And dissent comes in various ways. One of the ways in which the dissent can come up is through institutions of accountability and transparency. So you want to hollow out those institutions of accountability and transparency. That's the third thing which it seeks to do. And the fourth thing which it wants to do is, in order to ensure that all this is successful, you must have mass surveillance. Without mass surveillance, you can't succeed in all this. So this is the kind of project, apart from, of course, a very aggressive neoliberal politics, of which people talked about earlier also. Very aggressive neoliberal politics. So now look at these issues. Let's look at these issues and see how the Supreme Court has dealt with them in the last 5 or 6 years. I mean, let's just be very clear about this. Now, what are the issues? Okay? Look at, first of all, which is the institution of accountability. The major institution of accountability in a democratic country is the parliament. Now, how do you ensure that in the parliament you are going to succeed? Okay? In a way which undermines the constitution but which allows you to do what you want. So the first method they used, okay, is passing laws through the method of money bills. Okay? Which is what? A money bill doesn't have to be placed before the Rajya Sabha. Now there was a time when Rajya Sabha they didn't have majority, etc., etc. So you call a money bill is primary purpose of that, it's like budget. Primary purpose of that bill is to talk about finance. It deals with finances. Second thing is we must always remember that every law involves some financial implications. That doesn't make it a money bill. Money bill is one which has centrally which deals with finances. Okay. So what do they do? Aadhaar Act is passed through money bill as a money bill. Doesn't not placed before Rajya Sabha. Similarly, the entire change to the administrative to the tribunals, okay, controlling the tribunal structure by taking away their autonomy. Earlier, say some of the tribunals, the heads, I mean they were equivalent to election commissioners. Okay. So taking away their autonomy. Third thing, LIC privatization, the whole thing was passed as a money bill. Now all these matters went to the court, Supreme Court. How can you pass these things as money bill? In Aadhaar Act, the majority of the Supreme Court decided that no, there is nothing wrong. It can be passed as a money bill. I have still not understood the logic of it. Okay. Maybe I am too dumb to understand it. But according to some wonderful logic of Supreme Court, Aadhaar Act, which deals with identity of persons, is actually a money bill. This is something which Supreme Court in its wisdom has said. Fair. Okay. Now the other laws, the tribunal laws, etc., have been referred to a 7-judge bench. Forget that. Even PMLA, the amendments, the ED, the Prevention of Money Laundering Act, which has become the huge issue now. Okay? The amendments which deal with power of the ED, nothing to do with money. Okay? Power of ED to take statements, etc., etc. That was also passed as a money bill. So this is also these things are pending before the larger bench of the Supreme Court. But look at this. But the situation is this: that this is one way in which they are trying to hollow out the whole situation. Second way, Parliament, leader of the opposition. They say, from some logic, that unless you have 10% membership in the Parliament, 10% of the total seats, there cannot be any leader of the opposition. If there is no leader of the opposition, then many of the important appointments, like Lokpal, CBI chief, CBC chief, all those appointments require the leader of the opposition to be part of the selection committee. But if you don't have a leader of the opposition, then obviously that person is not there. So they said, so the government said there is no leader of the opposition because you don't have 10% membership. Where does this 10% come from? There is no law which says 10%. There is no law which says 10%. The only law dealing with this whole issue of leader of the opposition is a 1977 Act which deals with there should be a leader of the opposition. It doesn't talk about 10%, 5%, 15%. This is the interpretation of the BJP, that you require 10%. So that's the second thing. So that's how they are trying to undermine Parliament. Now that issue is also pending before Supreme Court. But we don't know when it will be heard. Okay. Similarly, if you see, Election Commission, the poor Election Commissioner Lavasa, he gave dissenting orders. He said Modi had actually involved in corrupt practices. So two things happened to him. One is the Election Commission passed a rule, the other two members, saying that dissenting opinions cannot be published. Okay? So you don't even know what the dissent is. Cannot be even published, forget anything else, cannot be published. Second thing is, there were income tax raids on him and his wife. Now this again is pending in the Supreme Court. Oh, chalte rahega in Supreme Court. Similarly, you see what has happened in CAG, that is Controller and Auditor General, which is the main financial auditor of the government, central government. All schemes, everything, every year have to go to him. His report is placed before the Parliament, etc. So who is appointed now on that? Murmu, not President. Murmu, who was the Secretary, Home Ministry, State of Gujarat, during the troubled times, and who has no experience of audit or accounts, he is appointed as CAG. This is what has happened. Again, that is challenged in the Supreme Court. We are awaiting the decision. We don't know what will happen. Similarly, if you see, a lot of statutory bodies. Now remember one thing, that India has 179 human rights bodies, state bodies, government bodies, 179. NHRC, then various state government SHRC. Women's Commission, various state governments. Minority Commission, various state governments. Child Rights Commission, SC/ST Commission, various state commissions. So there you have 179 bodies. What you do is hollow out those bodies by making appointments of their own people. So you change the criteria of who will be the chairman of NHRC by amending the law. Up till now, chairman of NHRC could only be a retired Supreme Court Chief Justice. But Mr. Mishra, Arun Mishra, is looking for a job, and he is not a retired Chief Justice. So what do? So you amend the law, and please remember, Mr. Arun Mishra was the one before whom 9 matters of Adani were taken out of turn, including in vacations, all decided in favor of Adani over a period of 1 year. Apart from various other ills which he has committed, this was one of them. As far as Mr. Arun, Justice Arun Mishra is. So he is made the chairman of NHRC. Similarly, various other institutions, whether it's Lokpal, Whether it's CI, they amended because see what, as a part of the process of centralization, what did they do? Information Commission, Central Information Commission was always appointed by central government. Now they amended the law, saying that under the RTI, saying that even state information commissions will be appointed by central. So that power is also taken away. That we will appoint the State Information Commission, pending in Supreme Court. What will happen, God knows. So this is the way they are following out all the institutions. I've just given you a few examples. There are many. You go to RBI, CBI, CBC, CBI matters pending in Supreme Court, RBI, CBC, following out of all institutions of accountability. That's one aspect. Second aspect, we come to surveillance. Surveillance, what is the situation? Today, I mean, Aadhaar is the most, the major mass surveillance exercise which was carried out. Aadhaar card. Everybody must have an Aadhaar card. Challenged in Supreme Court. Aadhaar upheld with some exceptions. So, what, you see, Supreme Court has got into this habit of passing judgments, which, if read in an international forum, would sound wonderful. Okay? Right to privacy. And 500-page judgment, wonderful. Okay? Right to internet, fundamental right. Look at Basi's judgment. Kashmir, internet blockade for 1 year. No, this is not something which we can permit. But at the end, what do? You please go back to the government and explain to them what we are telling them. That's the sum and substance of the judgment. That's the sum and substance. So you have these wonderful judgments which declare profound, great fundamental rights. But when it comes to actually doing anything practical, these judgments mean not much. I wouldn't say nothing, but not much. So you have Aadhaar. Today, everywhere you need Aadhaar, wherever you go, you need Aadhaar. Okay. Though Supreme Court saying that for this, it may not be needed for this. Every day they come up with notifications saying Aadhaar is mandatory for this, Aadhaar is mandatory for that, Aadhaar is mandatory. Supreme Court did not strike it down. Chandrachud gave a dissent saying that it should be struck down. Chandrachud's dissent is there, Justice Chandrachud's. Similarly, CA and NRC. You don't have a better surveillance mechanism than CA NRC. NRC, CA is one aspect. NRC will affect everybody. CA will affect the Muslims. NRC will affect everybody because unless you have proof that you are a citizen of this, unless you have proof that goes back to some God knows how many years, you will not be declared as a citizen. You are not declared as a citizen. You don't have any rights. You can be put in jail. You can be thrown out of the country, etc., etc. How many Dalits, how many tribals will have proof of date of birth and all that kind of thing? Registration of dates of births, okay, and deaths. There is a law which makes it compulsory. In 2017, only 40% of those people of births which happened in 17 were registered. Forget what happened earlier. Okay. So this is the reality of the situation we live in. What is going to happen to those 60% people? How are you going to prove? How are you going to do anything about it? Well, this matter, of course, is pending in the Supreme Court, CA, NRC, both. Then we come to Pegasus, which is very, very interesting. Because Pegasus is an instrument, it's a software, Israeli software, according to Israeli government, sold only to governments, found in quite a few people's phones. Now, what happens? Suppose somebody files a case against me, and I tell the court that court tells me to file an affidavit, and I tell the court I don't want to file an affidavit. What will the court do? Court will presume against me and decide against me. That's how the courts function. That the court is giving me an opportunity of filing an affidavit. I am saying I don't want to file. That means everything which is said in the petition is correct. You go. Here in Pegasus, the central government said that we refuse to file an affidavit. We don't want to disclose whether we have bought it. We don't want to disclose whether we have used it, this Pegasus, which is a surveillance listing. What does the Supreme Court say? Okay, we'll then appoint a committee. So they appoint a committee. What is the committee going to do? You declare, either you bought it or you not bought it, you disclose an affidavit. That doesn't, so Pegasus, look at the way the Supreme Court has functioned. It's completely, in favor of the central government. Then similar thing has happened in our Bhima Koregaon cases, where we have the report of international agencies which shows that in every case, whether it's Varavara Rao's case or whether it's Gautam Naulakha, whether it's Surendra Gadling, whether it's Hani Babu, fabricated documents have been planted on their computers. The documents on the basis of which they say that these people are guilty are actually planted on their computers. And internationally, we got their hard disk examined by international agency called Arsenal, which is in USA. And they have given 3 reports, and the 4th is about to come. They have given 3 reports which basically say that all these documents which they say that are missing are actually planted on the computers without the knowledge of the person who had the computer. There are ways of doing it, and they have found that out. We have filed petitions in the court. Nobody is willing to hear that petition because whether they are planted or not will be heard at the time of trial. Trial will happen at the end of 10, 15, 20 years, God knows when. So this is the situation. Then you come to the next issue of dissent. How do you crush dissent? And what is the Supreme Court's views on that? Now, the 2 most obvious things is what has happened recently in the case of 2 activists. One is Tisra Satalwar and second is Himanshu Kumar. You have a situation whereby both those persons collecting a tremendous amount of documents. And I was involved in Tisra's case right from 2002, so I know the kind of documentation which is there, kind of evidence which is there. We collected about 10,000, 20,000 pages of document to show how Modi, Shah and all were actually aware of what is happening. More than Shah, it was Modi at that time because Shah became a home minister a little later. They were aware of what is happening. They allowed it to happen and encouraged it to happen. These are the kind of documents we had. We kept on filing when ultimately when matter goes to Supreme Court. Supreme Court not only disbelieves us, which is one aspect, which I think is wrong anyway, but Supreme Court not only disbelieves us, but says that she should be put behind bars effectively. Similarly, in Himanshu Kumar's case, the judgment says that he helped the tribals. Yeah, ultimately, we all know that as human rights defenders, there are a lot of marginalized groups who, without the help of human rights defenders, won't be able to reach the court, won't be able to articulate what they want to do. People are needed. If you expect every tribal to reach the Supreme Court and fight a case, you're talking about impossibility. That's not going to happen, and that doesn't happen. So what? So Himanshu Kumar, same thing. Himanshu Kumar helped the tribals about the violence which had happened, went up to Supreme Court. Supreme Court throws out the case. Supreme Court not only throws out the case but says that prosecute Himanshu Kumar. Further says Supreme Court that in any case in India, anywhere, where these kind of allegations against security forces are made, prosecute the people who are making these allegations. This is what the Supreme Court says in Himanshu. So just imagine the response. Supreme Court's response, both judgments given by a bench of, I call it Khanvilkar jurisprudence. We used to have Krishna Iyer jurisprudence, now we have Khanvilkar jurisprudence. The third part of Khanvilkar jurisprudence is the PMLA. Okay? The Prevention of Money Laundering Act, where basically what the court has said is that ED, even if it registers a case against you, doesn't have to give you a copy. Doesn't give you a copy. Second thing is, if you make a statement before ED, it will not be treated as a statement before a police, because a statement before a police is not admissible in evidence. Which wisdom British had in 1860. Okay. When they said that, I mean, in the 19th century, not in 1860, but a little later, but the point is that they said that any statement made before a police officer is not admissible. But now they are saying, now ED ke samne, if you make a statement, now ED is nothing else but an arm of the police. Or police has become now an arm of the ED. You can look at it either way. But that's the situation. So what we have today is you will not be told what the allegation against you is. You make some statement before ED and it will be used against you in evidence. And that is why today now you have ED going helter-skelter across the world, across the country. And that was upheld by Justice Khanwilkar's bench just before he retired. And the fourth major contribution of Justice Khanwilkar to the human rights jurisprudence of India is a case called Watali. Watali is a case under UAPA. Because there is a fifth one I will come to that. Well, Watali is a case under UAPA. Which you have said here, posters are that UAPA should be abolished, etc. It was in Watali's judgment that the Supreme Court, speaking through Justice Khanwilkar, said very categorically that at the time of bail, whatever the defense may say has to be ignored. So if there is an allegation against me which is false, it has to be ignored. Whatever the police says has to be believed. And then you decide whether to give bail or not. And how do you decide to give bail or not? I mean, it's a very, so that is under UAPA. And obviously, as you have put up here, UAPA has to be abolished, has to be repealed, you know, because the purpose of UAPA is not to convict anybody. The conviction rate is very poor. The purpose of UAPA is to keep people behind bars for long times without allowing them the opportunity of getting bail. That's the purpose of it. When all these Bima Koregaon, Delhi riots, all these people are involved are inside because of UAPA. You know? And the fifth jurisprudential wisdom from Justice Khanwilkar is in respect of FCRA challenge. You see, foreign contribution, the large number of NGOs. Now, I am sure a lot of people here would have differences whether you should take foreign funding, not take foreign funding. It is a debate going on since the time I was young, and which was a long time back, let me assure you. And but apart from that, I am not getting into that debate. I am only saying that a large number of NGOs do work by contributions from whether it's Tista Secular CJP, whether it's Lawyers Collective, whether it's Human Rights Law Network, whether it's INSAF, whether it's organizations like Greenpeace. Okay, a lot of these organizations do get it. So that FCRA was changed, the law was changed, amended by the present government, making the requirement extremely stringent. I won't get into that. This was challenged in the Supreme Court, saying that, what do you have to say? Supreme Court said, no, nothing, this is fine, whatever changes are there are fine. So whatever, so you look at it this way, the organizations, okay, of marginalized cannot function properly because their funding is dried up, either through FCRA, or through UAPA, or through PMLA. So it becomes very, very difficult for any and the individuals who protest are put behind bars. Like it happened with Tista, like it happened with Sri Kumar, who is a wonderful, fine officer. With him happen. So these are the kind of, so also it is happening through the amendment to the IT laws, information technology laws. And they are also trying to bring out a data protection law now, the government, which will give complete control to the government about what data can be put, what data cannot be put, etc. So if you look at even the dissent part, okay, and there are many other examples, I won't even go into that. But look at these laws. Now, many of these laws, remember, came during Congress. These are all grand gifts of Chidambaram. Okay? No, sorry. See, the NIA Act was brought in by Chidambaram. The UAPA amendment making bail provisions impossible was brought in by Chidambaram. So you have a lot of these gifts given by the earlier regime also. But what this regime has done is mastered the art of using law to subvert the law. This is what this regime has been able to do. Then how do you use, see, remember one thing, authoritarian regimes don't always, and I'm not just talking about India. You go to any other authoritarian regime, not any other, but some of them, whether it was Egypt, whether it was Argentina, Brazil at times, they learn to use the law in order to subvert the law. That you can do a lot of things legally. Why look at extra legal things? Why go around shooting people if I can anyway put them behind bars for 15 years? In fact, there was a very famous statement by one of the Mexican generals. Of course, he was a fascist kind of a general. He made a statement that to my friends, I give justice and I give grace. And to my enemies, I give the law. So that's the kind of a situation that this government has mastered the art of using, and they will keep on doing it unless they feel that the courts are coming in their way. Okay? Now, today the courts are not coming in their way. Let's be very clear about it. You are arrested under UAPA, there is no way in which you can get out, okay, very soon. You are put under PMLA, there is no way in which you can be out very soon. Your FCRA is cancelled, your entire organization will have to go now. Okay. You are declared as like it happened with PFI, you are declared as an unlawful organization, and worse, want to say one thing, because actually I am arguing that tomorrow in the Bombay High Court. See, what they do is they declare an organization as an illegal organization, like CPI-MN, okay. Communist Party of India, Marxist-Leninist, is declared as an illegal organization, along with all its fronts. Okay. Now, nobody knows who those fronts are. Okay. So, what has been, like in Bhima Koregaon case, what has been happening is that there is a cultural group called Kabir Kalamanch. So in the affidavit, in the reply, in the bail application, they suddenly say that this one is, Kabir Kalamanch is a front organization. Why? How? Nobody knows. But they have declared it as a front organization and the courts accept it. In Stan's case, Father Stan's case, which I was handling, they filed an affidavit saying PUCL is a front organization. Okay. Now, I also happen to be in PUCL. So, of course, unfortunately, because of Stan's death, that part has gone off because you can't prosecute a dead man. So, you can't now call PUCL a front organization. That was involved only in that case. But this is the other thing which is happening, that they declare anybody as a front organization at any time. I can understand if you give a notice, you come out with a government notification, like PFI has a government notification, the PFI notification. It actually names the frontal organization. The PFI is banned along with its following frontal organization. The notification names it. You at least know who you are, whether you are in a banned organization or not. But otherwise, they don't even name frontal organization. You come to know who is a frontal organization only when you go to court. And courts allow it. Left, right, and center. Nobody questions it. Yeah? So this is the other thing. But finally, I come to the way the attacks have been on Muslims and the response of the judiciary. Ayodhya, we all know. I don't need to comment. It's a judgment which collectively as a country we should be ashamed of. Okay? That's the Ayodhya judgment. But there was a silver line in the Ayodhya judgment. And that silver line, and a very thin silver line, very marginal thing, was when the majority judgment, which I believe was written by Chandrachud, said that as far as the 1991 Act, Religious Places of Worship Act is concerned, that's part of the basic structure of the Constitution. And it cannot be touched. What does the 1991 Act say? 1991 Act says that whatever was the situation of a religious place in 1947, cannot be changed. So basically, thereby stopping Mathura, all the other things. Okay, that's what the Act. The Act also said that this Act will not apply to Ayodhya. That's why the Ayodhya case went on. When the Gyanvapi case went to Justice Chandrachud, he should have thrown it out on this basis that you are trying to change the nature of a place of worship which has been fixed since hundreds of years, and it should have been thrown out on that ground, but it was not thrown out. Okay. So what Ayodhya of course despicable. Gyanvapi is even worse. And my fear is it's going to open up a lot of new other cases, which at the first impression of Ayodhya, it has appeared as if Ayodhya is limited to Ayodhya. But that's not the case. Similarly, you see what happened in Kashmir, how the courts have dealt with Kashmir. 370 is not yet heard. Habeas corpus petitions for hundreds and thousands of people which were filed were never really paid any attention to by the courts. When you file a habeas corpus petition, you ask for that person to be produced in court. Instead, I think Sitaram Yachuri was asked to go there. I mean, instead of producing that person here, the court says, you go there, find out. Go there. Similarly, Ghulam Nabi Azad, who at that time, of course, was in Congress, filed a petition saying, I want to go there, I want to visit. They said, yes, but provided you will not give political speeches, you won't do this, you won't do that, you won't do that. And most of the habeas corpus petitions just respect there without any decision being taken. It is a complete abdication duty on part of the constitutional courts. And I have already mentioned what happened in Anuradha Bhasin's case about the internet stoppages and 144 and all that. So again, if you look at what happened in Kashmir, the Supreme Court's role has been pretty bad. Delhi riots, again, how do you have people in this kind of a situation lying in jail for 2 years, 2.5 years? Somebody, and all depends on which judge your matter will reach, because there are 35 Supreme Courts, as they say, there are 35 judges. Yeah? So before Tapan's case, after 2 years, more than 1.5 years, he was granted bail. Okay. Devangana was granted bail, Devangana and 2 others were granted bail. But with the condition that this will not be used as precedent in other cases. So the others, who are many more in jail, cannot use that precedent to get out, and they are languishing in jail for a long time. Oh, this is the other thing. Similarly, if you see the response of the court to Rohingyas has again been quite. If you are somebody who is in Pakistani jail, you will go to international court, you will hire Harish Sarve to appear for 1 rupee for you or whatever, and he will appear for you there. If you happen to be a Rohingya who is about to lose his life in Burma, if he is sent back to Myanmar, you will not pay that much attention to that case. You will not pay any attention to that case. Similarly, the demolition issues, bulldozer issue. What has the Supreme Court done? Nothing. No stay granted. In such a gross case, it is obvious that why you are demolishing these houses. So if you do not want to see the reality, nobody can show you the reality. If your eyes are not open, nobody can force them to open, force you to open your eyes. But this is what is happening, and there are a number of other. Hadia's case. Why did the Chief Justice and Justice Chandrachud order an NIA inquiry in a woman who converted and got married? What is the big deal about it? NIA inquiry. So, I am sorry, but same thing if you look at, Hadia's case is also an example of women's agency. You don't recognize a woman's agency, Supreme Court. Same thing has been happening in Sabrimala. Again, it has been referred to a larger bench, etc., etc. Bilkis Banu. What a shocking thing that 14 people charged, 12 people charged with murder and rape, convicted for life. State government has released them. Central government is not opening its mouth because under the law, state government could not have released them without the consent of the central government. Central government doesn't want to come out in open and say we consented to rapists being released on the same day when the Prime Minister is talking about women empowerment. It's a same Dalits. The major problem, apart from anything else, apart from the dilution of the Atrocities Act and all, is what our friends from Visakhapatnam were talking about: privatization. You privatize, you do away with reservation. That's the first thing. So, whatever limited employment opportunities in the formal sector the Dalits had goes away because any Air India, I remember I was doing a case, Air India, once it's privatized, reservation is out. There is no question of reservation because reservation applies only to public sector. So privatization also, you know the way the whole thing is going. I think my general assessment is that the judiciary has failed to in any way halt the Hindutva juggernaut. There will be some signs here and there. Once in a while somebody will wake up and pass some order here and there. But that really doesn't worry the establishment. If their core concerns are taken care of, if Kashmir is taken care of, CA/NRC is taken care of, then I don't think they are really worried about how the Supreme Court. Because remember one thing, that even the authoritarian governments in all countries need at least some legitimacy. And one of the ways of getting legitimacy is by showing to the world that we have an independent judiciary. They also need that legitimacy because in matters of finance, if you are trying to invite foreign investors, etc., you need to give them a comfort that judiciary is not just going to decide what we tell them on phone, but they will decide on the basis of some contract, some legal documents, etc. So they need some kind of a veneer of an independent judiciary, even the authoritarian states need. And that is the history of authoritarian states. Now, while I do say, I want to conclude by this, that while I do say that the Supreme Court and the High Courts have failed us as far as these aspects, by and large, failed us. It's a space, it's a democratic space. It's a space given to us by the Constitution. It's a space, and sometimes it's a space which we don't have a choice but to use. And so we must use that space whenever it's possible. Having hope from courts is different from having faith in courts. So we can, I mean, we all, Clifton is here and we all go to courts from time to time, or maybe all the time. At least I do. Okay, but the point is that we cannot lose that space. And I am an eternal optimist. I believe things are going to change for the better. They are not going to change for the better because people are fighting in courts. They change for the better if people resist on the streets. Courts are only a minor part of the struggle which we wage. But they are an important part of the struggle. That's all I want to say, and I want to stop there. Thank you very much.